2, 1.
This Honorable Court of Tennessee is now in session.
Thank you. Good morning to the attorneys. I want to welcome you to the Tennessee Court of Appeals. Your panel today consists of Judge Frison, Judge Davis, and myself, Judge McClarity. We will proceed as if you were actually in court, except you will not need to rise during your presentation. If there's anything that comes up, technical matters, please let us know once they develop so we can address those and resolve them before we proceed any further. Madam Clerk, are there any preliminary matters?
No, Your Honor.
Then we may proceed. Let's call the first case, please.
Buttercup Ridge Farms, LLC et al. Versus McFall Sod and Seeding, LLC et al.
For the appellant, are you prepared?
Yes, Your Honor. Thank you.
Have you reserved any time for rebuttal?
I'm sorry, I did. I reserved 3 minutes for rebuttal, please.
Thank you. You may proceed with your argument.
May it please the court, my name's Bruce Peden. I'm a member of the Murray County Bar. I represent the appellants who were the defendants below in this quiet title action. The plaintiff property consists of about 80 acres that lies 3,000 feet north of Highway 412. The property at issue in the case is a strip or lane of property that's 15 feet wide and extends from the highway northward 3,000 feet to the plaintiff property. My clients, the defendants, own land on both sides, on the east side and the west side of the lane. The plaintiff chain of title, a man by the name of Seth Brown acquired his property in 1973. That deed is the general bounds description deed, and it did not include the lane within the property description, nor did it include any reference to the lane. My clients acquired their property first in 1996 on the east side of the lane, and later in 2001 on the west side of the lane. Their deeds do not include the lane. The calls in their deeds, and both of those deeds extend up to the lane. Mr. Brown died in 2018. After he died, one of his grandsons, Stephen, who inherited a fractional interest, he and a family member formed an LLC, and they bought out the remaining heirs of Seth Brown. The plaintiff's quiet title was based on a claim of adverse possession. We defended on the basis that the action was barred by Tennessee Code 28-2-110, which is the non-payment of taxes for 20 years statute. Additionally, we denied that the plaintiffs had adversely possessed the lane. Your Honor, I'm going to see if I can get the full screen on here. Excuse me just a minute. Well, I'm not seeing the clock, so I don't know. I'm trying to keep up with my time.
Right.
I want to talk about two aspects, those two aspects, that statute and whether that statute bars the this action or not. The trial court held that it did not. The trial court also held that the plaintiffs had proven adverse possession by clear and convincing evidence. We take issue with both of those conclusions. That all of the tax maps showed the property as being part of my client's property, the McFall property. The nuance about that came from the testimony of the property assessor, who testified that these parties had paid taxes based upon their deeds. And he acknowledged that the tax maps showed or appeared to show the lane as being part of my client's property or taxed as part of their property. But he testified that you would have to examine the deeds to determine exactly who paid taxes on what. So the trial court initially made a finding that we had not proven the failure to pay taxes, but we filed a motion to alter and amend and a motion for additional findings. And in ruling upon that, the trial court specifically found as fact that the plaintiffs had only paid taxes on the property as described within their deed, and the property described within their deed did not include the lane. So with all respect to opposing counsel on the trial court, I really don't think I submit there's really not an issue about whether we proved that they had failed to pay taxes or not. The real issue is whether or not the Supreme Court's exception in the Cumulus case, whether that applies or not. And of course, in that case, the Tennessee Supreme Court carved out a narrow exception to the bar of 28-110. And I say narrow exception, that's not my characterization of it. That's the characterization of this court in the Butler versus Barrow case, which was decided in 2020. That is the case that we are relying primarily upon for the proposition that the cumulus slight overlap exception does not apply. First, in this case, I want to point out there is no overlap. In other words, there's no indication that my client's property overlaps the defendant's property or vice versa. And there's no indication that my client's property overlaps the lane or that the plaintiff's property overlaps the lane. We're dealing with a separate parcel or separate strip of land that's not included within either party's chain of title. That was precisely what this court dealt with in Butler versus Barrow. That case involved a 66-foot wide abandoned railroad right of way. And in that case, the court, Judge Clement wrote the opinion, pointed out that there was no overlap, that the parties were disputing over a separate parcel that had been separately conveyed and separately assessed for taxes. In this case, we're dealing with a parcel that has not been separately assessed for taxes. That's the only distinction between Butler and the facts in this case. I respectfully submit that is a distinction that without a difference, it makes no difference that the lane theoretically, according to the property assessor, may not have been taxed to either party because it was not included in either party's deeds.
What about when the testimony that the plaintiff actually paid more taxes on that 70-something acres? Was there some question about that? Your Honor, I don't recall any testimony to that effect. The trial court noted that in its order that the tax maps in the record showed 80 acres, for that parcel, whereas the deed called for 78 acres more or less. The trial court so the plaintiff was paying taxes on 80 acres instead of the 70-something acres or less.
That's right. That's apparently that's the case. The property assessor testified that they paid taxes based upon what was in the deed, and the trial court noted afterwards that the tax map showed it as 80 acres. But as I pointed out in my brief, if you examine those tax maps, that 80 acres was calculated acres and not per the deed. The trial court additionally made findings that the lane is not included within the 80.28 acres that the plaintiffs had surveyed, that their surveyor surveyed and identified as their property. So uh, getting back to the Butler versus Barrow, in my contention that it's a distinction without a difference is that the fact that it was non-assessed, okay, that's not a relevant factor, because the statute requires the property owner that's going to claim it to have it assessed. And that was specifically what the Supreme Court stated in Burris versus Woodward in 1984. And I would point out in that case involved mineral rights, but in that case, the plaintiffs had failed to pay taxes on mineral rights, and the defendants had as well. But because the plaintiffs had failed for more than 20 years, the statute bars their suit to recover the property. I can't state it any clearer than that, I don't believe. And I would like to just briefly turn to the issue of adverse possession, if I may. And the trial court did find that. And my contention is there's two aspects that were not proven by clear and convincing evidence. And one is exclusivity, and the second is adversity of the possession by the plaintiff, by Seth Brown. That's essentially what we're talking about, Seth Brown and the McFalls. And the point about that is, and what Mr. Brown did do is he put up a gate down at the highway, and he did put a lock on that gate. And I will concede that if you look at that would appear to be sufficient to claim adverse possession of the property. However, okay, he supplied the McFalls with a key to that gate. They always had a key to that gate. Additionally, the McFalls on the lane installed their own gates on both sides of the lane, where they could move cattle and horses from one side of the lane to the other side. It's true that Mr. Seth Brown would have used the lane much more often than the McFalls. No doubt about that, because it was the only access to and from his 80 acres. The McFalls have plenty of road frontage on both sides of the lanes, and they did not have as much need to use it, but they did use it. And Mrs. McFall testified that in terms of the lock gate, that they didn't have any problem with it because it protected their property as well. They didn't want anybody driving 3,000 feet up into their property without their okay. So in terms of the adversity between these parties, the record is clear. It's undisputed that there was never a problem between these parties, between Seth Brown and the McFalls. Never any serious issue between them. This lawsuit got filed after the grandson.
Your time has expired, or you do have your rebuttal time.
I'll defer to rebuttal. Thank you.
Sure thing. The appellee. Yes, sir.
Good morning. Ladies and gentlemen of the court, may it please the court. My name is Jake Wooliver. I do represent Buttercup Ridge Farms and Mr. Stephen Brown. I'll also be referring, as Mr. Peden mentioned, to a gentleman named Seth Brown, who acquired title back in the 1970s to this property and was my client's predecessor in title. If I could just to start, address the issues involving the statute of limitations, TCA 28-110. I think Mr. Peden and the appellant agree that the party that's trying to seek the protection of the statute of limitations must clearly show that the other party has failed to pay taxes. Your Honors, we believe that the analysis stops here. The tax assessor and his testimony is actually incorporated in the trial court's order, says that he couldn't tell who paid taxes on the lane. There was just a lot of different ways to look at how those taxes were being assessed. He acknowledged that if you just look at the tax maps, then it may be that the McFall property has paid those taxes. But he also acknowledged that the level of detail on those tax maps only goes so far. And on a 15-foot wide lane, that even the detail and the lines of the tax maps may not always reflect the actual boundaries. He then went to the fact that they try to base their assessments on the legal descriptions. But as Your Honor pointed out, the legal description for Mr. Brown's property called for 78 plus or minus acres. For some reason, he had been assessed for a long time before this survey had ever been done at 80 acres. The bottom line is that this witness, the property assessor for Murray County, Tennessee, Mr. Bobby Daniel, was called by the appellants, and the best he could do is say he couldn't tell who paid taxes on the lane. I can't understand a way that a party could clearly show something if the person entitled to keep, or the person who is legally charged with keeping those records says, I don't know who paid them. And to go beyond that and into the cumulus broadcasting case and what the appellant refers to as the slight overlap exception, I believe that in looking at the cumulus holding, the reason that the Supreme Court held what it held was that it said that tax maps and tax maps are just notoriously unreliable when it comes to exact boundaries. And it put in this exception that if the parties are contiguous, and I view contiguous as joining one another, and our parties do have contiguous parcels in this matter, but if they're contiguous, it doesn't matter how the particular overlap was taxed. What matters is that the respective parties have paid their property taxes. And again, this goes back to the fact that there are ambiguities in the tax maps, and Mr. Daniel's testimony reiterated that fact, that Murray County's tax maps are notoriously inaccurate when it comes to the fine detail of parcels. The appellant cites two unreported cases and dealt a few minutes ago briefly with the distinctions, but I would point out that in both of those unreported cases, in one, the parties weren't even, or the parties' properties were not even contiguous. They didn't join each other. They were actually separated by a separately assessed parcel that was assessed to a third party. The other case, the same situation where we've got a parcel that was separately assessed. In that case, it's easy to tell who paid the taxes because the taxes were assessed to one party or another, or in this case, a third party. The appellant calls this a distinction without a difference, I believe, but I would assert to the court that is precisely the difference that the cumulus court was dealing with and had in mind, that sometimes when these parcels are joining, it's just too close to tell. And it's not, did you pay tax on the disputed parcel, but it's, did you pay tax on your own parcel? And I would differ with the appellant in the fact that that makes a big difference. And that's the reason that the Butler and the Cash Rye cases, the unreported cases, refuse to follow or go a different direction from the cumulus case. I'd like to turn to the adverse possession issues and deal with those at least briefly. As the appellant points out in his brief, exclusive, actual, adverse, continuous, open, and notorious ownership is the standard, and it's a clear and convincing requirement on the party asserting adverse possession. This lane, and there's a nice picture of it in the appellant's brief. It's a beautiful country lane. It's surrounded by trees on both sides. But the first thing you notice about the gate or about the lane is the locked gate at the beginning of it. The proof at trial showed that this lane and this gate was in place when Ms. McFall purchased the property that adjoins the lane. There's no dispute that the gate and the lock and the fences belong to Seth Brown and now to Buttercup Ridge. This was never questioned by Ms. McFall or anybody asserting an interest on behalf of the McFalls. It's undisputed that the McFall tracks border the lane on both sides. And presumably Ms. McFall knew that when she purchased those parcels. It is true that she did have access for use of the lane, and I'll deal with that more in just a minute. But as we briefed extensively, that permissive grant of use does not negate either the exclusivity or the adverseness of the ownership that Mr. Seth Brown started and was continued on out until present day. The appellant states that there was no proof in the record to support the adverseness or the exclusivity of the Browns' use of the lane or Buttercup Ridge's use of the lane. But I would point to a few instances and a few facts that I believe point out the contrary. Number one, down the middle of this locked gated lane runs a water line that is undisputed belongs to the Buttercup Ridge tract. It also was there when Ms. McFall bought her property. There was an instance in which Ms. McFall or someone representing the McFalls tried to tap onto that water line to use in some irrigation equipment. Mr. Brown stopped that, and that testimony was not disputed, that he asserted control over that line and he stopped the use. Likewise, there's testimony by Mr. Stephen Brown that at one point during the course of these parties' relationships, the McFalls put up a gate that instead of running parallel with the lane, ran perpendicular across the lane somewhere in the middle of the lane. And I believe the testimony was that this was to run cattle and to stop the cattle from going down the lane maybe. But the undisputed testimony was that that gate was removed, and it was removed at the insistence of Mr. Seth Brown. These instances show, in addition to the fact that Mr. Brown owned the gate, owned the locks, and if anyone granted permission for somebody to use the lane, it would have been him. The fact that he was able to stop certain uses of the McFalls shows that he exercised complete control over this lane. He might have given permission to use it or cross it, but it went with his farm, and that's what his position on the matter was, and that's shown by the facts, and those facts were undisputed. At best, Ms. McFall called her use and the McFall use of the lane occasional, and they didn't use it a lot. They didn't. They would use it to cross from one parcel, maybe run cows or horses, but that was just an occasional use, and Mr. Seth Brown allowed that use. Again, to assert that a permissive allowance of a use would negate adverse possession flies in the face of the cases that were cited by the appellee. That just the fact that Mr. Brown was able to determine who got to use the lane and who didn't, and no one disputed that fact, it shows that he met all the requirements that adverse possession requires to gain possession of this property. The idea that the appellants put forward that by denying the quiet title and remanding this case back, that this leaves everyone in the status quo, well, that may be the case, but then we've got a tract of property that's not owned by either the McFalls or the Buttercup Ridge property, and I can't see that that's the best outcome for this case for either party. Nevertheless, we would assert to the court that all of the requirements for adverse possession have been shown. Those were shown by clear and convincing evidence, and the trial court adopted and approved that in his order. And ladies and gentlemen of the court, we would urge you to affirm the trial court's decision and dismiss the appeal. Thank you.
Thank you, sir. Yes, sir. Your rebuttal.
Yes, sir. Thank you, Your Honor. In terms of the cumulus discussion of that case and the slight overlap exception, 3,000 feet is not a slight overlap. And again, this is not a cumulus was a boundary line dispute between adjoining properties. This case concerns a separate tract of parcel that neither party can claim color of title to. In terms of permissive use, the council characterizes my client's use of the lane as permissive. There is no evidence whatsoever in this record that my client's use was permissive in terms of vis-a-vis Mr. Seth Brown, any more so than there's proof that my clients permitted Mr. Brown to install a gate and a lock on it that they had a key to. So the record, I respectfully submit, reflects what the Oregon Court of Appeals, it was a case I cited, and I realize that case, this court's not bound by that case, but that court was dealing with a similar situation and concluded that the parties had engaged in a cooperative and mutually exclusive use of the gap was the term in that case. And I submit that's what this record shows up until the point when Mr. Brown's grandson, a real estate investor, forms an LLC and buys the property and sues the McFalls. There's no evidence in this record of any incident where the McFalls have attempted to deny Mr. Brown or Buttermilk the use of this lane or access back and forth on this lane. So in terms of what Mr. Brown, and I didn't mention this, but I want to mention this, and it's at page 5 of Collective Exhibit 1. Mr. Brown, he died in 2018, and a few months before that, he signed his last will and testament, and he described this property in his last will and testament as being the farm being 80 acres, more or less, located 3.8 miles west of Columbia State Community College off US 412 West by a lane extending 3,000 feet north to the beginning of said property. So just a few months before he died in his last will and testament, Mr. Brown described his property as beginning 3,000 feet north of Highway 412. Now, that's not definitive proof. I will concede that, but that is some pretty strong, I submit, pretty strong circumstantial evidence. One, that Mr. Brown did not think he was paying taxes on the lane, and two, that Mr. Brown did not believe that he owned the lane. And I respectfully submit that the trial court got this case wrong. I asked this court to reverse the trial judge conclusion based on 28-110 and dismiss the case. Alternative, I asked the court to reverse the finding of adverse possession. It will restore the parties to the same status they've been since 1973, in which there's been no serious issue between these parties, and they have shared the use and possession of this lane. Thank you.
Thank you, sir. And your case now has been submitted to the panel. You will receive our opinion within a due course of time. Madam Clerk, will you please recess court until the next case is called, please?
This Honorable Court of Tennessee is now in recess.
Thank you.